Closing arguments in the trial of Derek Chauvin will begin Monday. The former Minneapolis police officer chose not to testify yesterday, invoking his Fifth Amendment rights. He's facing a maximum of 40 years in prison if the jury convicts him for the murder of George Floyd. CBS News correspondent Jamie YUCCAS reports on what's next from Minneapolis.
I will invoke my Fifth Amendment privilege today.
For the first time since the trial began, Derek Chauvin spoke in court while the jury was not present.
Do you feel that your decision not to testify is a voluntary one on your behalf?
Yes, it is.
And with Chauvin's decision to not take the stand in his own defense, the defense rested. Joe Tamburino is a Minneapolis criminal defense attorney not associated with the case.
Do you think he maybe wanted to testify?
I think he should have testified. You have to decide, is this person going to be good on the stand? Many people are not.
Then there was a stunning development that nearly led to a mistrial. The issue surrounded the defense expert testimony that carbon monoxide poisoning may have contributed to George Floyd's death.
Was Mr. Floyd's blood tested for carbon monoxide?
I could not find a reference to it.
It turns out the medical examiner had tested for it. The prosecution wanted to call back a pulmonologist to present those test results, but the judge said the testimony would be inadmissible at this stage of the trial.
But if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial. Pure and simple.
Dr. Martin Tobin was allowed to testify carbon monoxide poisoning did not contribute to Floyd's death. And with that, all testimony came to an end. Now, Minneapolis city leaders are stepping up security in preparation for the Chauvin verdict, which could come as early as next week. National Guard troops are already stationed in downtown Minneapolis, and barriers were placed near the courthouse and the streets surrounding it. Mayor Jacob Fry acknowledges with the Chauvin trial happening so close to where Daunte Wright was killed, the trauma of the community is palpable.
The mayor says the city put in several months of preparation and will be flexible and adaptable when it comes to protests by using state patrol deputies and other agencies. Jamie YUCCAS, CBS News, Minneapolis.
For more on this, I want to bring in Jody Armour. He's a law professor at the University of Southern California Gould School of Law. Professor Armour, welcome. Great to see you again. So what do you expect we will hear when closing arguments start next week?
Chance to frame the evidence, marshal the facts in the way that you say the narrative should be understood, your version of what happened. And the version that the state has painted is one that looks at Derek Chauvin as a monster, as someone who's callously indifferent to the value of life. The defense has to humanize him. At the end of the day, in some way, if they're trying to argue that even if he did something that was unjustified, he did it as an expression of human frailty. You know, police are people too. He was surrounded, maybe his judgment was clouded, but he's not morally condemnable to the point that he should be thrown in a cage. That's the defense's argument. Or even if he was a wrongdoer, his wrongdoing didn't cause any harm to the victim, to George Floyd, because George Floyd had pre-existing underlying conditions, and they were the cause, and the asphyxiation was not really the cause. So that's their two arguments. He was justified. The officer, if he wasn't justified, you should excuse him. If he's not excused, then his inexcusable wrongdoing was not the cause of any harm.
And Professor Armour, you know, as you pointed out, the defense argued there were many factors involved in Floyd's death, right, including perhaps drugs, heart disease, while the prosecution argues that Floyd's death was a direct result of Derek Chauvin's knee on his neck. How will the jury deliberations work? It takes just one juror to be convinced of the defense's narrative, correct?
Yes, and you would think that a question like causation is a kind of factual question, right? It's an empirical question. But we see that scientists can disagree on a factual question like causation. And so if scientists can disagree, if the medical examiners themselves can disagree, then, jurors could go back in that room, and we see that causation questions are influenced also by your value. That's what we're seeing in the different medical examiners reaching different conclusions. They looked at the same evidence, but they reached different conclusions because they were using different filters, different values to look at that evidence on causation. So now the jury can go back there and, like you said, all you need is one juror to say, I sympathetically identify with the defendant, Derek Chauvin, and I can express my sympathetic identification with him by not finding causation. I just don't think there's enough to prove beyond a reasonable doubt that there was causation, and you could have that would deadlock the jury. We'll see if that comes to pass in this case.
Right, because of course he is facing multiple charges, correct? And each charge has a slightly higher or lower threshold for getting through the jury, correct? So you could say, hypothetically, if that one juror decides, well, I'm, a little bit more sympathetic, perhaps that juror might be convinced of a manslaughter charge, correct?
Exactly. They're graded. These are homicide crimes that are graded. Manslaughter, murder, right? And then 2 counts of murder, 3rd degree and 2nd degree murder. All of those counts of murder are acknowledging that it was unintentional. It was accidental. But they're saying if it was unintentional but criminally negligent, you grossly deviated from what a reasonable person would do in the same situation, then that's manslaughter. But if they say beyond that, you were grossly indifferent and it was a depraved heart, you expressed extreme indifference to the value of human life, then they'll call that unintentional killing murder. That's 3rd degree murder. And then there's a felony murder rule that would make it 2nd degree murder we don't have to get into as much. So a juror could say, I think he's guilty of something. I'm not going to find him guilty of the higher crime, murder, in the 3rd degree, but only of manslaughter. Remember, in Minneapolis, a black police officer who killed Justine Damon was convicted of 3rd degree murder by a jury for that mistaken killing. So you can see that it's a real value judgment in a lot of ways.
Yes, absolutely. So, it is complicated and there are lots of factors at play here, Professor. Do you think we could possibly see this case result in a mistrial?
Oh, yes. Yes, look, we remember the case of Walter Scott. He was one of the hashtags in the early Black Lives Matter movement. We saw him being shot 6 times in the back as he was running away from an officer. And in the first trial, the jury deadlocked, despite that evidence that many of us saw of him getting shot 6 times in the back, right? So even when the proof is, the ocular proof seems compelling. In the Rodney King case, the ocular proof seemed compelling. The first Simi Valley jury acquitted, right? So you can never be sure until the verdict comes in.
Absolutely. Well, Professor Jody Armour, thank you so much for joining us. We appreciate all your legal insight.
Thank you for having me.